All information included herein is provided for general informational purposes by ATN Law Office. Bypassing intestate succession. What if you don't want to set up a will or living trust? That means any property in your estate will likely be subject to intestate succession, where the state determines who gets your assets instead of you choosing who gets to inherit. If you don't want to leave the decision up to the state, then you can structure your assets so you don't give up the power to choose who inherits. If you structure your estate properly, some of your assets will not be affected by intestate succession laws. You can also take assets out of your estate by giving them as gifts. Or you can use certain vehicles to bypass the probate process. Probate is getting court permission to legally transfer title of your assets to your heirs. If you put your assets in certain vehicles, then those assets don't have to be named in a will or to be probated. That's because you've already determined who inherits those assets. The following are some ways to bypass intestate succession. 1. Put your assets in a living trust to avoid probate. After you pass away, your trustee will ensure that those assets are transferred to your beneficiaries. 2. Titling your property as joint tenants with rights of survivorship, or characterizing it as community property. That means title is automatically transferred without needing court permission in probate. 3. Life insurance. Your named beneficiary receives the insurance proceeds directly within 30 to 60 days after you pass away. As the legal owner of the insurance payout, probate is avoided because there is no need to determine title to those funds. Other things to be aware of: your named beneficiary must be alive at the time of inheritance. If you name beneficiaries for your other assets, such as your IRAs, 401ks, or annuities, then probate is also avoided. If you name your estate as your beneficiary, then those proceeds will have to be probated in court because the title of the money has to be legally transferred to your heirs. 4. Payable on death bank accounts. Any money in a bank account will be owned by your named beneficiary upon death of the account owner. 5. Transfer on death registration for vehicles. In California, you can name a beneficiary directly on the certificate of registration, avoiding probate. 6. Securities in transfer on death accounts. This is like a payable on death bank account. Upon your death, a transfer agent will transfer ownership of your stocks, bonds, or other brokerage account, again avoiding the probate process. When you set up these vehicles, make sure it doesn't contradict your estate plan. For example, if you intended to divide your estate equally between your children, be sure you're not naming only one child on an account because that child is under no legal obligation to give any money to your other children. If he or she does honor your wishes, then it is a taxable gift. Make sure to leave enough assets in your estate to pay your debts, taxes, and other expenses. And in setting up these vehicles, be careful not to mistakenly forget to give something to a child or grandchild, resulting in an awkward situation for your named beneficiaries. You can structure your assets so that you may not need a will or trust, but that takes a lot of coordination and planning to avoid probate. If you have more questions, consult an attorney. Remember, planning is the first step in preparing for your future.